Hello, welcome to today's episode of The Law Show. Thank you so much for all of you who have been following our series. We've done a three-part series on the Land Use Act and how it affects, if any, the powers of the Barr of Benin. We did part 1, we did part 2, and then in part 3 we looked at community allocation documents and their validity, question and answer session. So today, and then somebody, part 4, we did part 4, I think. Somebody now asked, okay, with all this said, what is now the place, what is the worth of usefulness of the Land Use Act? And that was part 4. So it was our proposition that the Land Use Act is the most useless piece of legislation I've ever seen in Nigeria. So, and we advocated that the National Assembly should actually repeal it. So, because really, it doesn't give you anything. So we've done that. That's part 4. So today we'll be looking at part 5, a certificate of occupancy. How can it be a competent document? You know, there's somebody who really asks, what is the worth of a certificate of occupancy? Okay, what is the value? What is the worth of a certificate of occupancy issued by the governor of a state over land? And it is my humble submission now. Others may have their viewpoint, but it is my humble submission backed by law. And I'll show you the law, backed by law, that a certificate of occupancy that is given to any person who has no pre-existing legal or equitable interest in the land is a worthless document. In other words, a certificate of occupancy is worthless unless the person to whom it is given already owned the land. So the land must have been owned by the person in possession of a certificate of occupancy in order for the certificate to be valid. So if a certificate is given to someone other than the owner of the land, the certificate will be a worthless document. It will be a document that will only be good to be thrown into the dustbin, to be cast into the bin, to be cast into the compost heap. Okay? So that's important. That a certificate of occupancy is a worthless document unless the holder of the certificate of occupancy is the owner of the land. So in order to break it down, because I think this could be quite heavy for some people to follow, I know that this is, like I said, this is not it's not a comedy show. It's not, strictly speaking, an entertainment show. It is pure and simple a law show. So the purpose is to educate you on your rights, to get you to understand your law, to get you to, because you may come to a point when perhaps you have to defend your interest in your land, or somebody has acquired your land, like in one case where a governor of a state was approached by a big man who owned a parcel of land to sort of amalgamate his neighbor's land to his own. So the governor gave the big man one certificate of occupancy covering both the big man's land and the neighbor's land. So he now took the neighbor's land, by executive fiat. The governor gave somebody a certificate of occupancy over his neighbor's land. So the neighbor got to know for the first time when, he went to the ministry to try to make some payment for ground rent and discovered that, no, you are no longer the owner of the land. The governor has given your land to your neighbor. So obviously in that situation, and they were living on the land, so in that situation you would expect that the only thing it calls for is for a vigorous campaign, to nullify that certificate of occupancy. So and that's why I say certificate of occupancy is nullifiable. Whether it's over community land, whether it's over family land, whether it's over personal land, it can be nullified. Okay? So I'm just going to give you probably about 7 or let's say 7 conditions for the validity of a certificate of occupancy. I think we put it like that. So we have said a certificate of occupancy is a worthless document if you, the possessor, do not have title to the land. So that presupposes that there are conditions where the certificate will be valid. So what are the conditions for the certificate to be valid or invalid? You probably want to know that. And you try and write if you can. Otherwise, I would we'll try and put some notes for you if we can, if Owen can help us do that. So that some people who probably are not really lawyers may also be able to, follow and make a few notes. Okay? So number 1, for a certificate of occupancy to be valid, you must have, the possessor, the holder of the certificate, must have acquired the legal or customary interest of the owner of the land. Okay? So, point, there is still an owner of land. Every land still has an owner. So it's either individually owned or family owned or communally owned. There is no land that does not have an owner. So yes, section 1 of the Land Use Act says all land in Nigeria is vested in the governor of that state to hold it in trust for all the people of the state, for all Nigerians. Yeah. So it's vested in the governor. It doesn't say the land is given to the governor. Maybe I should read it because there are some people who have this wrong impression that it is the governor that owns land. And some governors actually act as if they own the land. Okay? So that's in section 1 of the Land Use Act. I could just read it. Subject to the provisions of this act, all land comprised in the territory of each state in the federation are hereby vested in the governor of that state. And such land shall be held in trust and administered for the use and common benefit of all Nigerians in accordance with the provisions of this act. So, just a few things you want to note there. Number 8 thing you want to note there is that the land is vested in the governor of each state. It doesn't say the land is given to the governor. It doesn't say the governor is the owner of the land. It doesn't say the governor is the possessor of the land. No, it doesn't say the governor is the one living on the land. No, it's just vesting. It's like we say in law, a vesting sort of arrangement. And what that means really is the land is vested in the governor, theoretically, to hold in trust. Trusteeship is introduced. The concept of trusteeship means that, there is an owner of the land, and then somebody is looking after the land for the owner. Okay, so that's the concept of trusteeship. There's an owner, then somebody is looking after it. There's a way it can be explained. I think it's written somewhere in the Bible where it says that a king, as long as he is an infant or young child, is still under tutors and governors, okay, waiting his maturity age. So even if the man is a king or whatever, it's a hereditary title, people will hold the kingdom in trust for him, and they have to give account. If they misuse their powers, there's going to be a problem. The same thing in estate administration. If a man dies, he has lots of properties and companies and all that, but his children are very young. They're not going to ask the child of 5 to become the managing director of a company now. Somebody will hold the company in trust for the child. Yes, he's the MD, presumptive MD, but, when the child comes of age, he's going to call him and say, how did you spend the money? And if he didn't spend it well, there's going to be a problem. So it is the same concept of trust that the Land Use Act uses, investing the land on the governor, that the land shall be vested in the governor to hold in trust. So he holds it in trust for the owner. How he uses it, the owner is going to, ask him questions. But in this case, the owner is not an infant. The owner is still on the land. The owner is using the land. The owner is, possessing the land. So that again is one of the funny things, funny factors of the Land Use Act. You know, while there is an owner that is preserved, the Land Use Act also vests trusteeship in the governor. Quite a strange concept, if you ask me, but that's why I say Land Use Act is the most, how do we put it again, Owen? The most useless piece of legislation in Nigeria, and it should be repealed, you know. Okay, so that's why we say that, because you can't put two contradictory concepts of ownership and trusteeship together, where the owner is an adult, is not under some physical or legal disability. Okay, but I guess you who is watching may have your view. This is the view of Dele Igbinedion. Okay, it's my view. That is a banker way of saying, I say my own, you say your own. No quarrel at all. No quarrel at all. Okay, so we've said that for a certificate of occupancy to be valid, the first thing is you must have acquired the customary or legal interest of the owner of the land. You must have gone to buy the land. You cannot get a certificate of occupancy over land that you have not bought. Just understand it. If you get a certificate of occupancy over land you did not buy, that certificate, if all the money you will pay for it will be wasted. It will be nullified by a court. The certificate does not give you a better title than you already had. As the name presupposes, it is not a certificate of ownership. It's not. It's not a certificate of ownership. It's a certificate of what? Occupancy. It's a certificate or a document that certifies that you are in occupation. So if you are not in occupation, the document itself will be a lie, and it will be capable of being nullified or nullification. All right, try not to speak any big English. So that's number one. Number two, the equitable or legal interest of the customary or legal owner must have been revoked before the certificate was given to you or given to any person. So this is where you need to watch out. If somebody has obtained a certificate, if you are watching this show and somebody has obtained a certificate over your community land, maybe he's building an industry, or government just gave a certificate over all your land, your people's land, to go and build one factory or this or that, you need to find out, has your interest been revoked? There must be an express revocation, okay? Revocation of your pre-existing interest. There must be a document that says the interest of Mr. Dele Igbinedion on this land is hereby revoked. A document must say so before the certificate is issued. If not, the certificate will be null and void. That's number 2 point. Okay. Number 3, the notice of revocation of your interest must have been personally given to you or anyone with a pre-existing interest in the land. So it's not enough for, governor or whoever, some people in the ministry there, they do all kinds of things in these government ministries, to just type, okay, with a computer, the interest of Mr. John Bull James has been revoked, signed, governor, and put it in the file. And when you complain, they say, your interest was revoked now. See, it is in the file. No. The law is that the notice of revocation must have been personally given to anyone with a pre-existing interest on the land. In other words, in fact, the law says you must deliver it to the person. You must go to the land, look for that person who is on the land, and give him the notice. Okay? This is a notice. In fact, you don't give him notice of revocation first. You must give him the notice of intended revocation first. In other words, when there is a plan to revoke his interest, you must first serve him with the notification that the governor is planning to revoke your interest. This is your letter, sign for it, sir. Okay? So, and after it is revoked, you must also give him the notice of revocation. These are technical and legal requirements. it's like the eye of a is it like the eye of a needle? Say, who can pass through the eye of a needle? How does the Bible put it that the head of a camel? It's easier to pass through the, how do you put it, Owen? Help me out.
To pass through the eyes of a needle than for a rich man
to enter the kingdom. It's more difficult to pass through the eye of a needle than for a rich man to enter the kingdom. So that's the thing with certificate of occupancy. Do people comply with all these requirements? They just go to government house, governor give them certificate of occupancy, and they come and say, oh, I've got a certificate over your land. Leave there. Police will say, he has certificate. Take him to court. Take him to court, and the certificate will be nullified. So that's number 3. All right. Number 4, on the condition for a certificate of occupancy not to be a worthless document. Otherwise, it will be worthless. The number 4 is that we talked about the fact that you must give somebody notice of intended revocation. Now, number 4, the person in receipt of the notice must have been given the opportunity to make representation. You see the problem? Before you can revoke somebody's, because this is his land, you want to take his land from him and give to somebody else. The law says before you can do that, you must give him the notice that you intend to revoke his interest in the land. By interest, I mean, you know what is ownership of the land. Then you must allow him to come and say something. You must set up a committee for him to come and talk to and say, look, I don't want my land revoked. I don't know this person. He has not paid me any money. I have, things on the land. I have this. The land has been in my family for centuries. You must hear him out. If you do not hear him out, the law says you cannot revoke. And if you revoke, the revocation will be null and void. If you just give a certificate of occupancy to somebody when the person who is on the land was not given an opportunity to come and make representations, that certificate is a worthless document. I hope you are hearing me. I hope you are hearing me. Number 5. You must have paid compensation to the person who is on the land. Yes. You cannot revoke somebody's legal or equitable interest. Okay, those are big terms in law, but what it means, you cannot revoke the right of the owner of a land and give the land to somebody else without paying him compensation. That will be illegal and it will be unconstitutional. You must pay compensation. So, how many people pay compensation before they get certificate of occupancy over land? This is why I tell you that a certificate of occupancy, without passing through all these formalities, without being the original owner of the land, is a worthless document. That's number 5. Number 6. Okay. Before the governor can revoke anybody's interest or ownership of land, the revocation must have been for public purpose. Public purpose. In other words, he cannot revoke someone's interest in land to give the land to another private person. It cannot work. You can't take from Peter to pay Paul. As one judge said, the purpose of the Land Use Act is not to rob Peter in order to pay Paul. No. It's not to turn tenants into landlords. It's not to turn servants into masters. It's not to turn customary tenants into the customary landlords. No. So, please note that the prior revocation of the pre-existing legal or equitable interest must have been done for public purpose pursuant to Section 28 of the Land Use Act. So, Section 28 of the Land Use Act defines what is called public purpose. Public purpose. Purpose for use by everybody. Me, you want to put a school there. You want to build a road there. You want to build a hospital there. something that everybody is going to use. Not for you not take from me and you give to Owen to set up a company on my land. No. A private company on land. No, it's not going to work. It will not work. So you cannot rob Peter and use the land to pay Paul. Please understand that. Don't get it twisted. Understand it. Any revocation of land that is not for public purpose will be null and void. Now, let me just give you one secret. Okay, are you ready? Public purpose means public purpose in its full definition. In other words, there is no private interest involved at all, even 0.0000001% of private interest. So if land is revoked, certificate of occupancy is issued to XYZ company, and that company is a public, how do they say it in these days, public-private partnership between the private sector and the government. It will not work. It will not work. It will not work because there's private interest included there. So it will not work. The only way it will work is if you revoke the private interest and use it for public. In other words, the company must be a public company, 100% public. No private. If you are public and you go and quote on the stock exchange and people buy shares, that is a sport. It will work again. Then you must use it for the purpose that you said you required it. You can't acquire it, for example, say we want to build a school, and 2 years later you start to split it and give it to party members, top party executives. It not work. Because that's the next one, the seventh and the last one I'm going to give you. The purpose, the public purpose for which the land is required must be spelled out in the notice of revocation. You must write it. This land is required by the government for sports ground, recreation ground, or a public park. And it must be run as a government facility, a government entity, a government parastatal. So these 7, please note it. If you miss any, I encourage you to watch this video again. And if you have any case, any problem, any situation where land has been taken from you or your family or your community without your consent by government and given to a private company, get your lawyer involved. Go and seek the nullification of that certificate of occupancy. Now, sometimes they won't tell you the certificate of occupancy. You can go to Ministry of Land to get it. You figure it out there. If they refuse to show you, don't worry, just file a suit. When you file a suit, they must bring out their certificate. They will bring it out. The one they have been hiding, they must bring it out to use to defend their presence on the land. Then you apply for an injunction. So you file a writ, you file for an injunction to stop them from further use of the land, from further entry of the land, and the court will always restrain them so that they don't change the nature and character of the land. They don't bulldoze all your ancestral, festival things, your shrines, the burial sites, things that are of emotional and sentimental value to people. They don't bulldoze all of it. Bulldoze your crops, bulldoze your cassava. It may just be cassava, but that is the mainstay of certain people. Okay, so these are things that you should note. I've given you seven things today on how you can declare a certificate of occupancy as a worthless document. I hope you've gotten something. If you have gotten something, you need to subscribe to this channel. That is the only way that you can at least encourage us and give us a thumbs up. If you don't subscribe, how will YouTube know that there are lots of people who are interested in this program? That's the only way. You need to subscribe. It doesn't cost you anything. Just click the subscription you know, what do you call it, subscription button, and then there's a notification bell. You know, ring it, click on the bell, and if you care, you are kind enough, give us a thumbs up sign. But if you think this program is not worth anything, there's also a thumb down. You can also give us. I don't mind. I just want to know, you know, what you feel. Or if you have any comments, please you can ask it. You know, or by way of a message, or you have certain things you want us. Okay, why don't we treat this topic? Why don't we look at this angle? Feel free to ask me. I can, you know, do it for you. I have no problem with that. And having said that, I hope we've given you something for today. Have a good day or good night or good morning wherever you are, and bye bye.